If you've been a victim of sexual assault, there are a few things you need to know. First, and most importantly, you need to understand this. You were assaulted. What happened to you is not okay, and it is not your fault. The person who assaulted you chose to do so. Some people blame themselves by thinking they should have been clearer, more forceful, or more careful. Some people question their own actions, but the truth is, none of your actions or choices have anything to do with the choice your attacker made when they assaulted you. Your attacker made the choice to violate you, and the first thing you need to know is that you did not cause this, and it was not okay. The second thing you need to know is that a crime has been committed, and there are choices for reporting and support. The process will take time, and it may be frustrating, even painful at times. But you don't have to do this alone. Let's talk about your rights and what the basic legal processes are. When you call 911, they'll send out an officer to meet with you. When the police arrive on the scene, their first priority is to keep everyone safe, which may include separating you from other individuals if they are present. A lot happens during this first interaction, so here's what you should expect. You have the right to be treated with fairness, dignity, and respect. That applies during this first interaction and throughout the legal process. The officer will take your statement of what happened. The officer will coordinate with the police department to connect you to advocacy services. An advocate is not the same thing as an attorney. Advocates do not represent you in legal matters or give legal advice. They walk you through the process of personal healing, connecting you to resources and navigating the criminal justice system. They are there to answer questions and provide support for you. Also, during this initial visit, the officer will assist with scheduling a forensic medical exam. This examination must take place within 5 days of the assault. The exam provides medical care and evidence collection. It is normal to be nervous about getting an exam, and you have the right to decide what portion of the exam you are comfortable with completing. The exam is provided at no cost to you. Before leaving, the nurse and advocate will make sure you have a safe place to stay that night and do further safety planning with you. After taking your statement, the officers will begin collecting evidence. Evidence can include clothing, sheets, video recordings, or anything else involved in the attack. You have the right to request the return of any personal property taken as evidence after it is no longer needed for the case should you choose. At this point, things can begin to get more complicated because there are a lot of things happening in the background on a lot of different fronts. After the report has been made, the police begin investigating your report to gather evidence to present to the prosecutor. An investigator, also called a detective, may be assigned to the case. Waiting at least 48 hours for a detective to interview you is part of the trauma-informed process, since research has shown that it can take up to 48 hours after a trauma for your memory of the event to stabilize. The time frame of investigating the crime varies, and the process may include interviewing witnesses to the assault, interviewing the attacker, and other evidence collection. The investigation will also involve getting warrants to seize evidence, follow-up interviews, and more. The time frame for getting the results back from the medical forensic exam varies and may take several months. You have a right to a speedy resolution of the case, but it's important to keep in mind the practical limitations of the investigation. It is the investigative team's obligation to investigate all aspects of the event, with the ultimate goal being to find out what happened and be able to provide evidence beyond a reasonable doubt. Throughout this process, you have the right to request certain information about the results of HIV testing, which your advocate can help explain further. As the investigation begins, your advocate will work with you on safety planning. Safety planning is exactly what it sounds like. You are making a specific plan for how to stay safe. Every safety plan is different and should cover your response to specific situations. Protective orders can be a powerful tool that comes with civil or criminal penalties if the respondent violates the order. There are several different types of protective orders in the state of Utah, including civil protective orders, sexual violence protective orders, and criminal protective orders. If you'd like to learn more about each protective order or apply for one, reach out to your advocate. Visit utcourts.gov, your local district court, or the police for assistance. Protective orders are an additional layer of protection. Violation of a protective order may result in jail time and/or a fine. Subsequent violations can come with heavier penalties. At your request, the detective on your case may be able to wait until you've obtained a protective order before they interview your attacker. You have the right to be free from threats and intimidation, not only during the investigation, but during court proceedings as well. After the police have completed their investigation, they present all of their evidence to the prosecutor. Depending on the amount of evidence, either during the investigation or upon its conclusion, an arrest warrant or a summons may be issued for the assaulter. In Utah, the prosecutor is usually the county attorney. The prosecutor represents the state of Utah and not you personally. The decision whether to prosecute rests with them, and their priority is public safety, including your own. You have the right to information about criminal justice proceedings and to have those proceedings explained to you. If they decide to prosecute, there are a number of steps before a trial would take place. If the prosecutor decides to pursue a felony conviction, there will be a preliminary hearing, where the prosecution is required to show their evidence that the defendant committed the crime. If they show enough evidence, the judge will bind the case over to the district court. As this goes on, you have the right to challenge subpoenas requesting your private records, but those challenges can be overridden. After the case has been bound over, the defendant can enter a plea of either guilty or not guilty. If the defendant pleads guilty, the case is taken straight to sentencing. If the defendant pleads not guilty, a pretrial conference is held for the prosecution and the defense to attempt to negotiate a plea bargain. Plea agreements are completely up to what the two parties can negotiate. The law does not require prosecutors to inform victims about plea agreements or seek their approval, though you do have the right to speak to the court regarding any plea offers and be present for important criminal justice hearings. You also have the right to speak to the court regarding the defendant's bail and sentencing. If no agreement can be made, the case goes to trial, where the defendant will be either convicted or acquitted. Your primary role in this process, after the investigation has been completed, may be to testify if the case goes to trial. If the prosecutor declined to pursue your case, your advocate and/or the detective may reach out and notify you. You may also receive a letter explaining why the case was declined. You may have the option to appeal to the Attorney General's office if you believe the case should not have been declined. Once your attacker has been sentenced, if he or she is sent to prison, then there may at some point be a parole hearing. The purpose of this hearing is to give the defense an opportunity to make a case for why the offender should have their sentence shortened or be approved for parole. Utah law requires that victims be notified of parole hearings and give you an opportunity to testify at the hearing. You will be given 3 to 4 weeks' notice that the hearing is taking place, though you may not have an exact time until it gets closer. You are not required to testify at a parole hearing, but your testimony may have a large impact on the decision of the board. If you are not able to testify, the parole board encourages you to write a letter advising them as to the impact the crime has had on you emotionally, physically, and financially. At the hearing, a waiting room that is separate from the offender's family and friends is available for victims. The hearing is open to the public and representatives from the media, though media are prohibited from photographing victims without the approval of both the victim and the presiding official. If you request, the offender can be removed from the room while you give your testimony, though the offender is allowed to listen to a recording of your testimony and respond to it. You almost certainly have more questions, and we'll do a recap at the end of the video. But there are many resources available through the entire state that you can access at any time to help answer your questions and walk you through the process. All the contact information for these resources are in the description of this video or on the webpage where the video is posted. First, the Utah Coalition Against Sexual Assault has a crisis line you can call. That number is 888-421-1100. UCASA also offers many other free services, including the You Are a Survivor mobile app, their sexual assault services map, and many others. Crime Victims Reparation is a group that assists victims of crime with various expenses. You have the right to compensation for your financial losses in the form of reparations and/or restitutions. Their number is 800-621-7444. VineLink is an automated service for notifying victims about the custody status of offenders in Utah prisons and jails. You can also register to receive automated messages by phone or email when a particular offender is released, transferred, or escapes. You can register at www.vinelink.com or at 866-277-7477. The Crime Victims Legal Clinic provides free legal representation to crime victims when the victims' rights issues are at stake. You can reach out to them at 801-746-1204. The Utah Domestic Violence Coalition also has a hotline. They provide information and referrals for people dealing with domestic violence issues. They offer crisis intervention and safety planning. They're available 24 hours a day and have access to 150 languages via interpreter services. Each county also has its own local resources available to assist victims of sexual assault. Your county's website should have information on these resources. So let's do a recap of everything we've gone over in this video. First, call 911. They will send an officer out to ensure your safety, take your statement, collect evidence, and connect you with an advocate. After the initial report, the agency will investigate the crime, which may require participation from you. Depending on the length of the time since the sexual assault, you may be asked to undergo a forensic nurse examination, but are not required to do so. The detective presents their evidence to the prosecutor, who makes a decision on whether there's enough evidence to prosecute. If the decision is made to prosecute, the prosecution and the defense may negotiate and attempt to reach a deal to avoid going to trial. If they are unsuccessful, a criminal trial will commence. You can petition for a protective order to prevent your attacker from committing additional violence against you. There are numerous statewide resources and local resources available to help you get through this. Every survivor's journey of healing is different, and they may take different amounts of time. Sexual violence crimes are difficult to prosecute. No matter what the outcome of your case, you still have access to resources to help you heal. You are not alone.